Well, hello and welcome, everyone. We're glad you could join the Rare Book and Special Collections Division and the Copyright Office for a lively discussion of early American copyright. This program is a celebration of new digital content now available on the Early Copyright Records Collection website. Over 200 handwritten copyright ledgers have now joined over 40,000 title pages to make available unique digital content. Today is also the formal launch of the new By the People crowdsourcing campaign entitled American Creativity Early Copyright Title Pages. This is a volunteer transcription service which will help make thousands of unique American documents more readily available to research. We have Stephanie Stillo available monitoring the chat, and we ask that you put all questions and comments there, and we will return the questions at the conclusion of all the talks. As a reminder, we are recording. And now on to our webinar. Our first speaker is John Cole, the library's historian, and his talk today will focus on Ainsworth Rand Spofford, the 6th Librarian of Congress, and his contributions to copyright. So without further ado, here is John Cole.
Well, Ainsworth Spofford, who was the 6th Librarian of Congress, really was an unusual man who played an unusual role in our great institution. He was the 19th century librarian who had the notion that the Library of Congress could be both the legislative and a public national library. And he discovered this during the period that he was Assistant Librarian of Congress from 1861 until 1864, and decided that he liked that idea so much that he would like to make himself or get himself into a position to be the Librarian of Congress so he could carry it out. But he had unusual traits that enabled him to do this. And in my research about Spofford and my writings, my favorite title really is one that is the Valiant and Persistent Ainsworth Spofford. He ended up being valiant because it was a tough job that required skills of a politician, but it was his persistence in persuading others that this was a good idea, especially members of Congress, that really enabled him to do the job. He came from Cincinnati, and where he really was, it was as if he was in training to become the Librarian of Congress and to do what he did. But of course, he didn't know it at the time. He was a New Englander. His family separated from their New England beginnings in 1845 when the father, the Presbyterian minister, decided that the family had to split up, and Ainsworth went to Cincinnati. Ainsworth already was a reader. He was self-taught. His brother Henry went south, went to New Orleans, and they ended up actually on the opposite sides of the Civil War. But it was Ainsworth's ability to move into the bibliographic world of Cincinnati that helped him, we now know, become the Librarian of Congress. He went to Cincinnati on his own, but he applied for a job as a bookseller. And he found that he loved that. He already was a reader, but it was the bookstore that he went to work in that really helped teach him these skills, and it was called E.D. Truman, bookseller. And Ainsworth didn't know until he'd gotten the job that E.D. was actually Elizabeth Truman, and it was her husband who had started it. But the skills that he obtained really, as a bookseller and then as a publisher, helped prepare him for this love of books and the job that he had to do at the library. He is remembered today in Cincinnati as one of the founders in 1849 of the Literary Society of Cincinnati. And that's where his friendships grew. And he also became a debater. He was very interested in public affairs. His very first talk at the Literary Society was about what turned out to be the trait that I think really, in addition to persistence, was his most important, and it was called enthusiasm. And he wrote about the importance of enthusiasm, and he actually did a kind of a historical survey gauging the degree of enthusiasm that some of the famous people in history had. And his conclusion really was that that was an important ingredient in achieving what it is you wanted to achieve. He also was a literary entrepreneur. He brought Ralph Waldo Emerson west for the first time as a speaker, and corresponded with Theodore Parker and Emerson, and he and Emerson became lifelong friends. But this was as part of the role that Spofford played in Cincinnati. His final role, though, was also important, but he was getting well known in the community and became an editor for the Cincinnati Commercial and wrote editorials on all kinds of different subjects. And in my research, I was happy to see the mention of copyright. He knew about copyright. He knew about libraries. In fact, he was very critical of the local librarian and his book buying habits. He also had a sense of the British Library. He wrote about the British Library, British Museum Library in those days, when he was the editorial writer. So these were ingredients of his knowledge that were important for him at the Library of Congress in just a few more years. He was in Cincinnati until 1861, but he came to really cover for the Cincinnati Commercial the first Battle of Bull Run in Washington. He'd never been to Washington, but something he started in Cincinnati was continued in Washington. He was writing for the newspaper, and he wrote some of his political opinions, which were radical for the day, under a pseudonym. Spiro sometimes, Spiro other times. While in Washington, he visited the brother of his best friend in Cincinnati. His best friend was Reuben Stevenson, who was the head of the Cincinnati Mercantile Library. And Reuben said to Ainsworth, while you're in Washington, why don't you check out my brother? He happens to be the Librarian of Congress. His name was John G. Stevenson, and he was a political appointee of Lincoln's. Lincoln's appointees were political. And Stevenson had really been Lincoln's campaign manager in Terre Haute, Indiana, but he got the job as librarian, his patronage, because of Henry Lane, who was a senator from Indiana whom Lincoln wanted to please. But it turned out that John G. Stevenson, the Librarian of Congress, really didn't care what job he had, even though he did not such an okay but job as librarian. He was also a surgeon, and what he really wanted to be was a battlefield surgeon. And he hired Ainsworth. His biggest achievement in many ways was having the wisdom to hire this earnest young man who obviously had library knowledge and experience and book experience as his assistant librarian. And it was from this experience then Stevenson went off to the battlefield and served himself nobly, but let Spofford run the Library of Congress, which at that time was in the U.S. Capitol, just 5 or 6 positions, I think 6 positions. Spofford became the assistant, but he was in charge. And a couple of the things that he did really led to his development of this feeling that the Library of Congress could be a national library. First, he wrote 2 annual reports, one for 1871, which was unsigned, one for 1862, which Stevenson signed. Stevenson was going to be librarian, it turned out, for another 3 or 4 years. So Spofford had to stay on good terms with him, but he was very critical of the state of the library, as actually Stevenson was too. It was small, it was neglected, and it was under the thumb of the chairman of the Joint Committee on the Library. And that was James Pierce from Maryland, who had definitely had Confederate Southern sympathies. And when Spofford's friend, Ralph Waldo Emerson, visited him in the library in the Capitol again in 1862, and this comes right out of Emerson's journals, Spofford said, well, the Library of Congress is in real trouble. It's under Southern domination. It's as if under dead men. But what happened was he saw the potential and we got excited about it. And as early as 1863, he actually wrote an article about what the United States needed was a public library that also was a national institution, but it could never happen unless Congress got off the dime and paid attention to the importance of books, reading, and libraries. That's about the time Spofford started to stop his criticism and his pseudonyms, because he also was very critical of members of Congress. And I think that was the period where he decided that he wanted to try to become the next Librarian of Congress, and that's the good politician. He had worked closely with a number of Cincinnati and Ohio congressmen, John Sherman, Rutherford B. Hayes, James Garfield, in particular, back in those early days. And Garfield and John Sherman and Hayes all supported him once he came to Washington and became the Librarian of Congress. And Spofford went so far, and this is part of this persistence idea, of actually on the walls of the Capitol tacking up petitions, which we have in the archives. If you think I've done a good job as the assistant librarian, would you endorse me to become librarian? This was in the period really in 1864 when Stevenson had gotten himself in some trouble, and it looked like it was fiscal trouble and some other questions, and that he might be leaving. And so the word was out, and Spofford got more than 200 members of Congress to endorse him. The other element in his character that appealed to members of Congress was he was a terrific reference librarian with a wonderful memory. And he had to have a wonderful memory because the books were in piles and the library was badly overcrowded. But he became known, as a one-person encyclopedia. And people when congressmen, especially after he became librarian, congressmen would rely on him, and that helped him win friends for his National Library idea. There were several important ingredients to this National Library idea that Ainsworth Spofford had developed. One of them was Americana collections. He thought it was important that any country should have a national library that reflected the nature of the literature of the country. And in his editorials back in Cincinnati, he talked about literature and books and about libraries, as I mentioned. Once he was named Librarian of Congress, he looked again at this idea of national collections and the need for Congress to have more support. And one of the very first things he did was to convince Congress in 1867 to appropriate $100,000 to purchase the Peter Force Library. Peter Force was an archivist, also the mayor of Washington, but really a historian who had a marvelous collection of books and manuscripts. And Spofford, with the help of historian George Bancroft, and he got Bancroft, Spofford was really wily. He got Bancroft to give an estimate to Congress how much it would cost to buy the Force collection, and that estimate was $100,000, and guess what? That's exactly what Congress did, and Spofford seized on that to really establish the basis for the Library of Congress's Americana collections, books and materials about our country, and our incunabula collections. He also had another good friend in Washington, Joseph Toner, and in 1882, after Spofford had already moved into almost mid-career, he persuaded Toner to give his 40,000 book collection and some manuscripts to the library as a gift. And that set a precedent again for strong Americana collections, which today are featured in the library's Rare Book and Special Collections Division, but also throughout the Library of Congress. There is a special report that Spofford worked day and night to try to write to convince Congress, but it was the friendship, I think, with Bancroft, who then later came in and used the Force collection and wrote about what a valuable collection it was. But the big baby, as far as Spofford soon realized that copyright was the big one. Copyright in the United States started in 1790, but it was a function of the district courts. And so people, in order to get protection, intellectual protection of what they've written or drawn or whatever the law required, had to register it and put in deposits, different kinds of deposits showing what they were going to do. But it was a highly decentralized collection. And you recall Spofford knew about the British Museum Library, he knew about the French Library, and he decided that what America needed to do was to tidy up its copyright system, and he didn't quite have the goal of centralizing immediately. He instead looked at what had happened, and there are certain years when the Library of Congress, in fact, got one copy of a deposit that someone needed to give to an institution in order to get it registered. But those copyright laws were not enforced. In fact, between 1846, when the Smithsonian was built, created, and 1859, both Smithsonian and the Library of Congress got copies, but it wasn't enforceable. And that was dropped in 1859. Other institutions got involved, Department of Interior, Patent Office, and Spofford got two new laws to try to enforce the deposit requirement. They didn't work, and then finally, this was 1865 and 1867, finally he went all out with the effort in 1870, and he got a hold of Senator Thomas Jenks, head of the Patent Committee, also had Cincinnati connections, and got him to add an amendment to the current revision of the patent law. It would centralize copyright deposit and registration at the Library of Congress. And there is a wonderful letter in April of 1870, a 9-page, beautifully handwritten letter, when Spofford outlines the reasons why centralization of copyright at the Library of Congress was in the American interest. And his friend Rutherford Hayes, by then a member, guess what, of Spofford's Library Committee, endorsed that and helped persuade President Grant to sign that in 1870. I should mention that in passing, that the Library Committee, it was headed by Mr. Pierce for so many years. One of Spofford's lucky breaks, looking back on this, was that Senator Pierce, who had been the conservative chairman of the committee from 1846, died in 1862. And that, I think, was one of the reasons that Spofford, I don't know this for sure, but he saw the opportunity because he put his Cincinnati Congress friends on the committee. And guess what? They loved this idea of a national library, and they went along with the centralization of the copyright as well. But the downside of that, and Spofford knew it would happen, was the space problem in the overcrowded Capitol. And in 1871, the year after copyright was agreed to, he, in his report, said, we got to have work on a separate building. We're going to be flooded. And that's what happened. He started to get flooded in the Capitol. And he soon, in 1876, said, if Congress doesn't approve a new building, their librarian is going to be presiding over the greatest chaos in America. Well, they still didn't. And Spofford then took space in the Capitol, and eventually those copyright deposits went into 16 different spaces in the Capitol. But he kept fighting, and Justin Morrill from Vermont was on his side with another senator and a senator from Indiana. And they really liked Spofford, they liked what he did, and they also felt that the Library of Congress should have a separate building. And that building, today's Jefferson Building, was finally authorized in 1886. Spofford had gotten every one of the presidents in those years to endorse the idea and egg Congress on to open the building. And when the building opened, of course, it had grown considerably. But when construction started, Congress really got interested. They didn't like the way things were going. They fired the architects. They brought in the Army Corps of Engineers, and this was a great period in our history when Civil War had been settled, Washington, D.C. was growing, nationalism was all over the place, and the Corps of Engineers, Thomas Lincoln Casey, had just finished the Washington Monument, extending it from its half pole, really, in the early part of the country, and extending it to its full height. And the next job they were given was this Library of Congress, and they believed that this could be a national monument, and Congress loved the Corps of Engineers, and the appropriation kept going up. The plan got bigger. It became the monument that it is today with the support of members of Congress. The building itself really was a National Library tribute. The public loved it, and Congress loved it, and the library was really on its way. The final thing that Spofford did was to, through his activity and his dominance of the Library Committee, he convinced all of Congress that the Library of Congress, once the new building had opened, needed a new structure, a new support. It would not be part of the civil service. It would have its own civil service, and its reorganization involved giving the Librarian of Congress the power that the Congress itself used to have. The Congress really, in that sense, became an advisory board to the library, but today, the Librarian of Congress really has the power that Spofford took himself for the librarian's office in 1860, last day of 1864, and continued. And he finally stepped down and became Assistant Librarian of Congress when that reorganization of the library, after hearings in 1895, the 1896, the reorganization of 1897 really created the Library of Congress's structure as it has grown. Finally, copyright and the building were really the two elements that got Spofford his national library. We moved from being a small legislative library to a public institution. It was a public institution all the way for him, so he created that part of the library as well. But copyright really was especially important because it really established forever the national prestige of an institution that would grow with its collections because of the law. And it really created a new opportunity for a building that previously, an institution had previously really not been on the map very much. And copyright, as we know today, is greatly magnified in complexity and what it does, but it remains really an extremely important element of the Library of Congress, as does that deposits collection. Once copyright was created, Spofford wrote to all the district courts and said, would you send us your deposits? And that deposits and the title pages of many of those deposits have formed the collections at the Library of Congress that we now are moving into a grand new project that will honor both Spofford, but especially honor copyright and the Library of Congress itself.
Okay, our second speaker will be Zvi Rosen, who is the assistant professor at Southern Illinois University School of Law, and he's also a copyright scholar. He was the 2015 through 2016 Abraham L. Kamenstein Scholar in Residence at the U.S. Copyright Office and taught at Hofstra, University of New Hampshire, and New York Law School, as well as Southern Illinois University School of Law. He has written extensively on the historical development of copyright and trademark law in the United States, with a focus on 19th and 20th century, early 20th century. Today, Zvi will speak about the legal history of copyright in America from 1790 to 1870.
Thank you, Elizabeth. And thank you, John, for that wonderful talk about the history of the library. My name is Tzvi Rosen. I'm a lawyer and law professor at the Southern Illinois University School of Law, and I've studied the history of copyright in America. So following John's talk, I'm going to give you more of a legal history of copyright in America for 1790 to 1870 to give greater context for this wonderful digital repository and crowdsourcing project the library is launching for these records. So the origins of printing alive or printing press is the ability to cheaply print multiple copies of text raised new concerns. Initially, the chief concerns were blasphemy and sedition, especially significant as Reformation and its wars spread along with new printing technologies. In England, Queen Mary I gave the Worshipful Company of Stationers a royal warrant to regulate and control all printing in England, which eventually continued through the long reign of her half-sister Elizabeth during the Stuart dynasty of the 17th century. As time went on, regulation of sedition and especially blasphemy became less important, and protection against piracy of literary works became more important. So following the Glorious Revolution of 1688, complaints by authors like John Milton and John Locke, it was increasingly difficult to justify using a refitted medieval guild to prevent piracy in books. Instead, England adopted a system of copyright premised on the author's rights in their writings, with Statute of the Act in 1710. Expanded in 1734 to include engravings at the urging of William Hogarth, this law would have been known by at least some lawyers in the colonies, but mostly as trivia. As colonists, they had no right to protection under English copyright law. Following the revolution, different states began passing copyright laws, each one requiring compliance with the unique provision of that state's law, mostly requiring separate registration in each state. The system was unwieldy, but offered American authors protection for the first time. After drafting the Constitution, what records exist show it was relatively uncontroversial for Congress to have the power to create a federal copyright system. At the urging of President George Washington and authors like Noah Webster, in the first Congress, the 1790 Copyright Act became law, and the story of the copyright collection begins. So a bit of legalities here. The very first copyright law gave Congress power to make copyright laws. Congress passed one in the very first Congress in 1790. It was limited to books, maps, and charts, though in 1802, prints were added as a fourth category. And in any case, courts tend to interpret these categories literally. The term of copyright under this law was 14 years, but a second renewal term of copyright was also available to the author or their heirs. So this was to obtain a copyright under 1790 Act, an author or proprietor, which is generally the publisher, would need to go to the clerk of a federal trial court, aka the U.S. District Court, for his or her state or region of the state, complete registration form, and the language is right here, and pay the clerk a fee of 60 cents, which by the way is over $100 today, with a certificate of registration costing another 60 cents. In addition, the author or proprietor would need to simultaneously deposit a printed title page for a work being registered, and these title pages deposited with registration form part of this digital collection. And you can see both the front and back each have important information. Following this, registrant would need to publish notices in a newspaper for 4 weeks within 2 months after registration. After a final book, map, or chart was printed and published, 2 complete copies needed to be deposited with the Secretary of State. In 1802, an additional requirement was added requiring notice of copyright on the work itself, which is now accomplished through a C and a circle symbol that we all know and presumably love. So this slide shows an analysis by Ruth Shaw Leonard of what was registered in the first 10 years of 19th century Massachusetts. The process, though, was expensive and cumbersome, and surprisingly, most books published were not registered for copyright. In fact, for a decade of 1790 to 1800, only 779 copyright registrations have been found, even though approximately 15,000 American imprints from a period are known. Of those registered, even fewer complete works were deposited with Secretary of State. A contemporary list shows that only about 1,000 were deposited between 1796 and 1822, even though there were nearly 5,000 registrations during those years. There's no easy way to assess compliance with newspaper notice requirement of a law. The general consensus is that it was followed even less than the deposit requirement. Also problematic is if the process was decentralized, with clerks of U.S. district courts keeping records of copyrights being registered among many other responsibilities. Some courts, like the District of New York in Manhattan, which would later become a Southern District of New York, had a very high volume of registrations, and kept records on an organized fashion in pre-printed forms. Other courts with lower volumes of records handwrote registration records. This is an example of a printed form which was used for copyright registration in Ohio. So the clerk would have a legal printer pre-print those form, and then they would write in the parts that were unique to each registration. In this case, registration at issue was litigated in the 1849 case of Scoville versus Toland, which held that an unadorned product label was not protectable by copyright. This, on the other hand, is a handwritten registration from the early days in Minnesota. These pasted in decorative labels are quite common in record books, especially in the 1860s. Other courts had much lower volumes and record keeping was haphazard. There's some early records from states like Connecticut, Maryland, and others going missing, although we're still looking for them. This also led to situations where the clerk of one district court would refuse to register a copyright, while the clerk of a neighboring district court would permit registration to be made. The dual deposit system set up in 1790 and maintained through 1870 creates an additional phenomenon. Annoying problem for record keeping at the time, but a gift to scholars now, the ghost books. In some cases, there would be a registration accompanied by a deposit of a title page if the work was never completed or published, leaving the title page as the only remainder of this ghost book. Until 1831, the copyright registration system remained largely static in its structure. The scale of the system increased dramatically. In the 1790s, district court clerks were handling an aggregate of approximately 50 registrations a year nationally. By 1831, it was more like 1,000 a year nationally. An update to the system was needed, and Noah Webster, by now a grand old man of American letters, returned to Washington to lobby for such a change. His nephew, Representative William Ainsworth, introduced the measure in Congress. On February 3rd, 1831, President Jackson signed it into law. So the biggest change of 1831 Act was the extension of the initial copyright term to 28 years, while the renewal term remained 14 years, a total of 42 years. However, the new law also subtly changed the mechanics of copyright registration. The fee was reduced from 60 to 50 cents to keep pace with deflation, and to help encourage deposit of finished works after registration, it can now be deposited with a clerk of a district court instead of being sent to Washington individually. And the clerk of a local district court would then send them to Washington in bulk periodically. Also, the requirement of newspaper notice was officially abolished, except for renewals. One change to the new law, which applicants would not have noticed, which can now be grateful for, was a requirement that clerks of a district court send lists of copyright registrations to Washington, D.C. This second set forms a useful backup in case the court records cannot be found. 3 years later, in 1834, the act was amended to allow the clerks of a district court to record transfers of copyrights, and many of these assignment record books have survived to this day. Over this period, the subject matter of copyright steadily enlarged, going from books, maps, and charts to include drama, music, print, and photography. This in turn led to an increase in the number of works being registered. By 1846, the district courts were receiving roughly 2,500 registrations a year, and Congress realized that copyright deposits could be more than just evidence for litigation, were in fact a repository of America's creativity. The bill establishing the Smithsonian Institution passed in that year, and as part of that law, deposit copies of New Smithsonian, the Library of Congress, was now required in addition to the 2 copies deposited the Secretary of State. However, compliance with this new law varied. In 1855, Congress made postage free for all copyright deposits. Even so, in 1856, the Library of Congress received about 430 deposits, while the district courts recorded 10 times that many. The Smithsonian did not appreciate receiving all these deposits of copyrighted books, and the Library of Congress at the time largely acquiesced to having these additional deposit rules removed. In 1859, Congress moved all copyright deposit business to the Patent Office, then the relatively new Department of the Interior. The Library of Congress was now the outside of the copyright system. Now, this didn't sit well with Ainsworth Spofford, who John has already told you a bit about. And Ainsworth Spofford engineered 2 amendments to the copyright law of 1865 requiring deposit in the library again. In 1867, there were money penalties added to the system to have a sanction against failure to deposit. Even that, as John said, didn't really work. By this time, even with these changes, it was clear further reform was needed. The obvious solution for Spofford's dreams of the National Library was removing confusion of using district courts for registration, moving all registration activity of the library to Congress. But in any case, the number of registrations being filed was skyrocketing. For early years of the 1790 Act, fewer than 100 registrations were filed a year. By 1868 alone, the number of registrations was over 9,000. Centralized national administration of copyright law was increasingly necessary from a practical standpoint. Now, John's mentioned a little bit about the background of the 1870 Act, but from a more legal perspective, this was the only ever omnibus intellectual property law in American history, which included the 1870 Copyright Act included within it, which transferred all copyright records to the Library of Congress, both going forward and also ordered all records be sent to the library, which have been kept by district courts over the previous 80 years. So yeah, under the law, district court clerks were to transmit the records to the Library of Congress. Most jurisdictions complied, but some did not. And I did a project a few years ago to put these records online in association with George Washington University School of Law. And that collection is currently online. And I'm happy to share a link to that. And with the 1870 Act, copyright material began pouring. This is all of the records that are not in the Library of Congress, but I put online. With the 1870 Act, copyright material began pouring into the Library of Congress faster than the library could process it. An 1874 amendment moved copyright for commercial prints and labels to a patent office, where it remained until 1840, but even so, the volume was immense. Under the 1870 Act, registrants would submit a title page and registration like before, leaving the title pages in the library's collection from after 1870, which they would deposit complete copies of a work after publication, again unchanged from previous laws. The need for a place to house all this material will lead to the construction of what is now the Jefferson Building of the Library of Congress. Once again, John's on a better version of telling you about that, where the materials remain to this day. Now, with a program to scan these materials, we are pleased to make this catalog of American creativity available to researchers around the nation and the world. A few projects to catalog the copyright records have been done before, including a volume published by the Library of Congress, a registration from 1790 to 1870, and a few lists of state records published by independent historians, generally focused on state with few records. However, with the digitization of the records, we have the opportunity to harness the power of the internet and of the American people to finally create an organized record of what was being published and registered for copyright in the early days of the United States. To this end, the Library of Congress is launching a crowdsourcing campaign of the pre-1870 title pages. You can help unlock this creativity through the By the People crowdsourcing platform. Launched in 2018, By the People is a volunteer engagement and collection enhancement program by the Library of Congress that invites the public to explore and transcribe the library's collection. When transcriptions are completed by volunteers, they're integrated back into the library's online catalog alongside the collections as full text data sets. Volunteer-created transcriptions improve search, readability, and access to handwritten and typed documents for everyone, including people who are not fully sighted. To date, By the People supports over 26,000 volunteers who have completed over 360,000 pages from the library's collection. This project, at close to 100,000 pages, we have the largest project done by the people so far. And this is an example of a crowdsourcing platform and how it looks to actually transcribe a page, which I did earlier today. So with that legal history told, I'm now going to turn to George Tironi, who will be talking about the Copyright Office and finding yourself in copyright.
Okay, our final speaker, am I on here? Yes, our final speaker of the day is George Tironi, who is the head of the Office of Public Information and Education at the United States Copyright Office. And George will be talking about how the early copyright records fit into the full range of the 230 years of copyright records housed at the Library of Congress.
Find yourself in copyright. That's the theme of a new exhibit the Copyright Office has launched on the 4th floor of the Madison Building of the Library of Congress. And it also goes to the heart of the exploration of copyright records. Copyright records reflect the progress of literature, photography, music, sculpture, and many other creative works from the early days of our democracy up to and including today. They truly reflect the mint record of American creativity. We're very fortunate that nearly the entire record of copyright registration and legal documents about copyright are contained within the Library of Congress as a whole. As V pointed out, there are a few missing pieces, which I'm sure he'll find, but for the most part, we can trace a substantial part of American creativity over a long span of time through these records. The early copyright records you've been hearing about are contained in the Rare Book and Special Collections Division of the Library of Congress. Records from 1870 through the present are managed by the U.S. Copyright Office. Those are the modern records. I guess I use that term rather globally for modern. So I'm going to talk a bit more about those records from 1870 through the present time. This will give you the full picture of what is available. Copyright records span more than 230 years, and exploring the entirety of these records might trigger your inner detective, because you do have to do a little sleuthing. There are several pieces, and I'm going to try to make that a little easier for you today by outlining what those pieces are and where you can find those records. So from 1870 through 1978, copyright information was recorded in large, hardbound ledger books. And those ledgers include information on registrations and on assignments and transfers of copyright ownership. Books from 1898 through 1945 contain hand-annotated records for applications that were created on cardstock. Books from later years contain paper applications. There are more than 26,000 of these books on our shelves in the Madison Building at the Library of Congress. We've just begun a program to digitize those records, starting from 1978 and moving chronologically back in time. The reason for that is that the most recent records pertain to works that are under copyright protection still to this day. And those books contain pre-printed application forms that are filled in by hand or by typewriter. You remember those typewriters? The older books, they're completely handwritten. The books are separated by years, and in the older books, by the type or class of copyright registration. In other words, books, printed music, maps, and so forth, whatever the different categories were. And in the coming months, as we continue the digitization, you will be able to search through those first sets of books, and that will be on copyright.gov. Everything I mentioned is on copyright.gov, by the way, so be sure to visit there after this presentation. So another way of accessing copyright records is through our cards. Over the years, the copyright record books I mentioned have been indexed on cards. And some of those cards are the actual application that was printed on cardstock. In all, we have 45 million cards that comprise the largest card catalog in the world. Those cards span the time frame from 1870 through 1978. The information in those records typically include name of author, title of the work, copyright registration number, and effective date of registration. The card catalog also contains entries for transfers of ownership, generally one card for each title, and assignee and assigner for copyright transfers and assignments. Over the decades, with changes in cataloging rules, the cards were organized into several chronological periods or indexes. They're here shown on this slide, and there are different idiosyncrasies in each of these. So it takes a little digging and exploring to find out the differences in the different time periods. There are also indexes that include assignments of copyright ownership, notices of use, commercial prints and labels, and a pseudonym file. There are also cross-references so that each copyright claim might have different access points. For example, you'll find a card for Gone with the Wind under G for Gone and under M for Mitchell as the claimant. And of course, there are many other cards for the derivative works of Gone with the Wind, each one of which would have its separate copyright registration and claimant cards. In addition, there might be cards for renewals. So there are several entry points to find a copyright record and associated records. So do you have to come to Washington, D.C. to this largest card catalog in the world to look for these? No, you're in luck. Through a project that took many, many years to accomplish, all of those cards, all 45 million, have been digitized and are available in a system we call the Virtual Card Catalog. Imagine walking through a large room with many drawers of cards and opening a drawer and looking at the cards. That's how the Virtual Card Catalog is designed, to mimic the card catalog. It's searchable too, but that does have some limitations. Many of the early cards were handwritten in a beautiful style called library hand. That was a script specifically designed by Melville Dewey and Thomas Edison for writing legible catalog entries. However, modern optical character recognition still hasn't gotten the hang of that 100%. Those might be a little bit more difficult to find through searching, but we are working on perfecting those records. Next, another access point, and those are the CCEs, the Catalog of Copyright Entries. So those cards that I mentioned, the same cards that are indexes for the registration records, those cards were captured in book form, which was published yearly, and that's the Catalog of Copyright Entries. The books enabled people to search through the records without having to travel to Washington, D.C. and look at cards. The cards were deposited in federal depository libraries around the country. And those book entries were published from July 1891 through December 1977. There were 660 of these volumes arranged by year. The very first CCEs contained simple entries of titles and claimants entered as they occurred with no index and no registration numbers. Then in the mid-1890s, sequencing by claimant and title were introduced. Some of the early CCE volumes have the claimant name centered over multiple entries of works registered for the same claimant, such as photographs and musical works. Starting in 1898, the entries contain more facts and were arranged by author or by title for periodicals, music, and anonymous works. And an index by claimant and title was included. From the mid-1970s, they're arranged by registration number with an accompanying name and title index. Now, all of these volumes, the CCEs, have been digitized in partnership with the Internet Archive, and you can find a link to those where? Copyright.gov, that's right. Now, to the next phase of records. In 1976, as many of you know, there was a major revision to the copyright law that took many years of legislative work, and its effective date was January 1st, 1978. So from that time to the present, copyright records are available through an online digital system that can be accessed by anyone through our website, copyright.gov. The system used to access those records has changed at least 3 times in the method by which the records are accessed. But each time the system was updated, the data were migrated from one system to the next. Late last year, we launched a new pilot system for searching those public records that includes many features familiar to you from Google, Bing, and other search engines that you use every day. And you can find online the records of copyright registrations and legal documents about copyright from 1978 through the present. And that system is going to launch more broadly next spring. So please try it out. We'd love to have your feedback. We'd really like for you to try it out and work on it, see what you can find, and let us know, and we'll improve the system before it goes online in the spring. So why should these records matter to you, and how can you find yourself in copyright? Well, as V mentioned, the original term of copyright was 14 years with a 14-year renewal. The duration of the copyright term has been extended several times since 1790, and the current term of copyright is the life of the author plus 70 years. For works made for hire or pseudonymous or anonymous works, the duration is a little longer, is 95 years from publication or 120 years from creation. It's calculated a little differently. So for that reason, many copyright records are relevant not only for historic purposes, like the early copyright records we've been talking about, but also to help establish copyright ownership, which would be more relevant to the modern records. As of January 2021, works after 1925 may still be under copyright protection, depending on whether or not they've been renewed and other factors. And next January, that will move forward 1 year to 1926. So there are a lot of works covered under copyright, and our systems will help you find out which ones are. So the early copyright records are really fascinating from a historic point of view. And as one moves forward in time, they become important from a legal standpoint as well. We really encourage you to explore copyright records of all sorts, from the past through the present. Why? Because everyone who has ever taken a picture, written a blog, composed a piece of music is a copyright owner. You own copyright as soon as you create something in a tangible fixed form. Many of those copyright owners have taken advantage of the benefits of copyright registration. And those records form this beautiful composite history of creativity in the United States and abroad. So I think you can see now why it takes a little investigative work to get a full picture, because there are different pieces to the puzzle. As we progress technologically, I think more and more of those will come together through a unified search. So eventually, we hope that you'll be able to search all those various sets of records through one single search. But please be patient. In the meantime, it can be a lot of fun to search for the history of a particular work, for a favorite author, an artist, a photographer, or a musician, or for your own self if you've registered a copyright. We also invite you to join our By the People campaign, helping us create digital records from the many scanned images. You can make your mark on these records. So please dive in deeply and find inspiration, creativity, empowerment, and history, and find yourself in copyright.
Okay, what a perfect way to end that. Thank you, George, and thank you to all of our speakers. That was absolutely fascinating. And we have some really great meaty questions that have come in. And I have to say, you have such a you have such wonderful speakers that they've been actively answering your questions, but I want to make sure that everybody gets to hear their answers. So we'll just kind of start at the top and see how far we get in the next 20 minutes or so. Zvi, I think you answered this in the questions, but let's go ahead and probably kick this one to you. So prior to federal copyright, did individual states have their own copyright offices?
I can jump in first on this one. Yeah, so offices is probably a strong word. In most states, like in Connecticut, the Secretary of State would sign copyright registration, and we know of about a dozen of them. That's the most. In a few other states, there were like a handful of them. You have some interesting stuff, like in Massachusetts, there was a mandatory deposit at Harvard University under the state copyright law. So yes, but and these all lasted only about a decade until 1790.
George, John, do you have anything to add to that? Okay. This is actually a question that probably is for Elizabeth. Are there plans to digitize and release those remaining 19th century copyright ledgers that are not yet available at lock.gov? Can you go ahead and tackle that one?
Yes, absolutely. We have plans to launch them as they're available. We have upwards of 800 plus items. We've digitized all the title pages, but we're still continuing with the ledgers and also probably letters. So stay tuned. They'll be launched as they're available.
Great. So a lot more good stuff to come.
Yes.
So, okay. So the next question, perhaps for George, but again, sort of anyone can jump in here. So current copyrights for a creative visual digital artist is how many years? And is there renewal? Can one do a collection of original digital artwork? So it's a big question for you.
Right. Thank you for the question. So copyright is kind of medium agnostic, and whatever your creative work, whether it be a digital image or a painting or photograph, they're all covered in the same way as far as the protection of copyright. So yeah, it's the life of the author plus 70 years. There are some differences if you're talking about work made for hire, things like that. But for most individuals, it's the life of the author plus 70 years.
Okay, great. So are past census documents part of this collection? And so we have someone that calls themselves a newbie genealogist researcher, genealogy researcher, which I liked that term a lot. So, and they suggest that seeing those transcribed, or at least being able to find them, would be very helpful. So again, the idea of our census documents sort of part of this.
Well, I put in an answer on this one.
Yes,
and I'll
thanks.
say, yeah, no problem. The census documents themselves are those are federal government produced. They're not going to end up at the library, as far as I know. People may know more of an idea on that. But there's a lot of genealogical interest here. For starters, obviously, if the ancestor wrote a book, that's extremely interesting. You can have lots of title pages of local histories, of city directories, which are of course incredibly important to genealogists, and other resources. So all of those are in the copyright records. They're finding those books. So books themselves obviously are not going to be necessarily part of this, just the title pages.
Great. Anyone else? So this is a great question that I don't know that we're going to be able to get to today, but you can definitely email me, and I'll put my email in the chat. But is there a hope or plan to use some sort of linked data to connect the transcribed title pages from the by the people to their registrations, which I think is a fabulous idea. Elizabeth, do you have any thoughts on this?
I do actually.
Great.
We will be using the transcribed data from the crowdsourcing campaign to populate the background for searching for the online collection. And eventually we'll have all the ledgers digitized and the title pages there. And if you do a search, it would ostensibly bring or marry the two items together in one search, or you'd have several search results in which they would come up. So yes, eventually we will.
Great. That is very exciting. So this is a question for anyone that wants to jump in. And we have a couple that are sort of related to artists here, which is really fun. So when did US copyright law begin to cover the visual arts like painting and sculpture? And I would like to say that attached to many of these questions is a thank you for a wonderful presentation. So I am not saying that, but you should visualize that after most of these questions. So painting, sculptures, when did US copyright law sort of come to encompass those?
This is like the last one that I gave the answer for, so I'll jump in first once again. Well, yeah, well, I mean, this is what I write about. So sculptures and paintings were added in 1870 as part of its big omnibus revision, that also brought copyright to the library. Engravings were added earlier in 1831, and prints were added in 1802, so very early. I strongly suspect that you had a lot of this stuff registered as a print or a photograph when prior to when it was officially being added. And one wonderful thing with this collection is you can now go into records and actually answer that question once and for all. Look what was actually being registered and say, hey, look, this wasn't supposed to be registered, but it was. So I think we're gonna have a lot of discoveries like that from these records.
Right, I think we've discovered that people were testing the law in the early times. So sometimes things were registered or attempted to be registered before laws were passed.
And I'd also jump in and say that clerks very, very rarely refuse to register anything. Among other things, they literally got paid by how many registrations they did. So don't assume if something's there, it would have been valid at the time. But on the flip side, it also does give us a wonderful window into what people want to protect.
Okay, so this question is for John. With such a rich history with the Library of Congress and Spofford, do you think that the library could have become what it did without Spofford? Oh, John, you're muted.
I got it.
Thank you, Nancy.
Well, the answer, I guess it really wasn't obvious from my talk, but no, I think the Library of Congress would not be where it is without that National Library idea, which Spofford really rammed through. As I point out, really as a person who woke up as assistant librarian and said, hey, I'm in a position in an institution that really should be the National Library. He knew about the British Library. He knew about the Bibliothèque Nationale from his Cincinnati days when he wrote editorials about them. So he knew about national libraries, and he had that connection to get into the Library of Congress. And suddenly he found himself running the place while the assistant librarian. And I didn't mention in my talk, but his friend, Ralph Waldo Emerson, I did mention it, in fact, I guess, came and Spofford said, the place is terrible. In 1862, we can't get anywhere with this. It's under Southern domination. Then suddenly the head of the library committee dies. And Spofford in 1863 started writing about all that's needed is congressional understanding that we have a great civilization has got to have a great library. And that is what we have here. We just don't have Congress's idea, and we don't have it open to the public. So my answer really is he is the single most important figure in creating the Library of Congress that we know today.
Wonderful. So what is the history of coverage of sound recordings?
This one is right down the middle for me. let's keep this under a minute.
You can go for longer than a minute.
Sound recordings were not protected by federal statute until 1972. You have some very early cases where the Supreme Court held that, basically that the federal statute didn't protect them, and then the 1909 statute didn't include them. So until 1972, they were covered by various state laws and state common law. As of February 15th, 1972, they're covered by federal law, and so they are today. And of course, there's separate copyright for music and sound recordings.
Right. And then, so actually, Zvi, I have a question for you, which is, you are very in-depth in this. How did you come to this as a field of study?
My honest answer is I was really interested in copyright records because of how important they are. And George has talked about that. And so then I came to the Copyright Office as scholar in residence, thinking I would focus, and I kind of did focus on the post-1870 records, but I got really interested in the pre-1870 records also. And I said, oh, wow, this is an incredible resource of American creativity at the birth of a republic and this era. And it's wonderful to go to a rare book room. It's an incredible setting, but it's difficult, especially if you're not in the DC area. And I said, if we put these online, it would enable everyone to use and see these CVs, to see how important the copyright system is, and frankly, really understand much more about the history. There is a research project in every single record in this collection, and most of these have not seriously been looked at before. And so, yeah, that's why I did it.
Very interesting. All right, so there's another question for, do works still need to be registered with the Copyright Office?
Yeah, so that's a great question. And it's true that as soon as you create something, a song or a photograph, or write something down and fix it in a tangible form, then you are the copyright owner. But there are benefits to registering, and one of the most important benefits is that if there's somebody who steals and uses your work or infringes your work, then you can take them to court if you have registered your work. So that's one of the main advantages of registering.
Yeah.
Plus, it also creates this public record, which we are all very excited about. So that's another advantage as well.
Okay. So I had, for our newbie genealogists and anyone else that's interested in genealogy, I had several of our wonderful reference librarians that are tuning in remind me to direct you to Ask a Librarian, Local History and Genealogy. And so I popped that into the chat, so everyone will have that link as well. If there's any other questions, you can throw them in the chat. And we will continue on. So the last question that I have here, but perhaps more coming in, which actually it looks like there are. All right, so given that a copyright registration is required to enforce your rights in court, is it fair to say that there is no longer such a thing as, quote, common law copyright?
Common law copyright was abrogated by the 1976 Copyright Act and only exists for sound recordings now. For all sound recordings, I should qualify.
It's a very lawyer answer, Zvi. It was very direct.
I'm sorry.
No, it was great. It was just ready to go. Great. Let's see. All right, I think we are running out of questions. All right. Does Germany or France have comparable institutions to the LOC? I'm assuming in terms of this type of copyright engagement.
I think copyright is separate from the National Library in those countries. And so in that sense, they really aren't comparable. The Library of Congress is unique in terms of it combines certain executive functions in other countries, not to mention legislative. And so we are rolled into a unique package, which doesn't compare in many ways to other national institutions. I'm not exactly sure. Steve, you might know how copyright is handled in Germany and England, but certainly not through the National Library.
Yeah, I mean, so copyright, every country has its own copyright version of whatever their copyright laws are, but there are international treaties, the Berne Convention and others that govern cooperation between countries. So there is a lot of cooperation in enforcing copyrights between countries, but each country has its own copyright law, some of which are similar to ours and others are quite different.
I'll add, so Germany and France, I know France, I think Germany operates under an authorized rights model where there's no formalities involved in copyright. It just is for mode of creation, which is what we have to a degree in the US, but there's no optional registration even. England, I think, is a little more complex because we, of course, and I mentioned this, modeled our system on how things used to be in England. And they had a system for a long time where there was a recording of records, and those are now viewable in the records of a stationer's company. And I actually think there was just an announcement of a digital repository of stationer's company records. So if you're interested in England, that could be relevant, but they never, and there was a requirement of deposit in the Royal Library and Oxford and Cambridge and other universities there, but it was always much more decentralized and less official and less formal than it was in the US with the Library of Congress, which is, of course, why the Library of Congress has gotten this really unique collection, I think.
So is there a policy on the retention of deposited copies?
Yes, that's a good question. The Copyright Office retains the copyright deposits, in other words, the works that have been registered. And the main reason for doing that is because if somebody does file an infringement case, we can provide a certified copy of the original work that was deposited with the Copyright Office. So works that are published, which are freely available, more so than unpublished works, we retain for 20 years. Works that are unpublished, which may be only one of a kind or one of very few, we retain for the entire copyright term, which is 120 years.
Could I just comment quickly? I got a minor correction on common law copyright, but I don't want to cut this conversation off. Oh, someone pointed out, and they're right, that there is common law copyright for unfixed works. There's a case involving Hemingway where a conversation that was had that wasn't written down was held to be protected by common law. Sort of a limit, so there are a few other very limited vestiges of common law copyright.
Right, very good. So there are a few very interesting things that are coming through on the chat as well that are more just comments. So our panelists can sort of take a look at those as well. Is there a plan to digitize 1870 through 1898 images of colorful labels and other images that have been organized by Rare Books and Special Collections interns over many past years? And I was going to make a joke about, is this from an intern from one of our past years, but it is from Rosemary, who has organized our interns over the last years. So thank you, Rosemary. Elizabeth, do you have any thoughts on this?
If they're what I'm thinking about, these are the title pages that the interns did start to organize, and they are definitely already been digitized, all of the title pages, and then we're moving through the rest of the collection. So I believe the answer would be yes, if I have the right collection in mind.
Great. So
Stephanie?
Yes, sir.
I saw across the bottom of the screen a question that got started about Solberg, who would be listed as the first register of copyrights, and actually officially he was. But it was actually Spofford who was the acting Register of Copyrights, as well as the acting librarian, as well as the Librarian of Congress, right up until 1897, when the reorganization of the library took place in the Appropriations Act for that year. But as Elizabeth knows, we did some work on the website about the history of copyright. And we talk about the Spofford as the advocate, but also an advocate of getting rid of the job of the Register of Copyrights that he advocated, Solberg, but that couldn't happen until the position was created, I believe in 1897, right, George, with the new law?
Yeah, that's right. He certainly, Ainsworth and Spofford was, he did call himself the Register of Copyrights, but he was overwhelmed. I mean, he testified before Congress and pleaded for money and for a new department to be set up. And in 1897, a new department was set up within the Library of Congress, and it was called the Copyright Office, which had a Register of Copyrights, which was a separately paid individual.
Right.
So that really took the pressure off of him.
Well, you could see from the photos that you saw talk about being overwhelmed. I mean, Spofford was completely overwhelmed with physically, and he used, I think I mentioned in my talk, 16 different storerooms beneath the Capitol. And that photo which you saw of the copyright deposits piled in the new building was in 1897. And the library in the Capitol closed for the summer of 1897. And the deposits and all of the materials were hauled across the East Capitol, East Plaza, and dumped in the new building. And that was what those deposits looked like for a year or two until they could be sorted out and then cataloged and classified. But so the registrar, however, was somebody that Spofford welcomed, and I think he felt such a sense of relief when he became assistant librarian in 1897 and spent the next until 1908 when he passed away in the position of chief assistant librarian.
So another question has popped up. Will the unpublished copyright deposits become part of the library's collection after 120 years?
George? That's a good question, George.
So we haven't gotten there yet because this system of keeping things for 120 years started with the 1976 Copyright Act, which went into effect on January 1st, 1978. So we've got a little while until we have to make that decision. I'm not sure if any of us will be around at that time.
All right, and Maria commented, thank you, Maria, that she has already found something wonderful in the newly released material. And she asks if it is okay to share it on Twitter. Absolutely, please share it on Twitter. Yell it from the hills. We are very excited about this. So with the link would be great. So yes, we are delighted that there's already people that are digging in. All right. Oh, yes. Thank you, Lauren. Please tag crowd _LOC for sure. Any other questions coming in through the chat? So far, we look like we're sort of wrapping up here. Elizabeth promised us a spirited discussion, and she was not wrong. There's some really great questions that have come out of this. All right. It looks like we are starting to gear down. And sounds good. So I want to really thank our speakers, John, George, and Zvi, and then a special thank you also to Elizabeth Gettens for putting this all together. There has been a lot of work behind the scenes with this, and she has been she's been tirelessly getting this done. And so we really want to thank her for all of that. And of course, also thanking our colleagues in the crowdsourcing department that do such a wonderful job. And they are working also behind the scenes to get all of this material to you. So again, thank you to everyone. This was a wonderful program. And we will have a recording sent out also so you can have all of this wonderful information at your fingertips in the very near future. So have a wonderful rest of your day and a great long weekend. And thanks for joining us.